Good morning, members. We have today the second meeting of the Subcommittee on Building Planning Amendment Regulation 2026. We have a quorum. The representatives from the administration have come inside the conference room. I call to order the meeting of the subcommittee. Before we go into the specific discussions, I would first like to talk about the administration submitted some papers. We also received a submission. It has been uploaded onto the LegCo website. Members raised different concerns, and the administration has provided response to the issues raised. I will now ask Mrs. Alina Chan to brief members on the two responses. Members who wish to speak may press the request to speak button. Thank you, Chair. Good morning, members. Let me first brief members on the response provided by the administration to the submission. The submission talked about for different facilities, we should have elderly friendly building design features, as well as general infrastructure. We already have 20-odd encouraged measures regarding elderly-friendly building design, and 11 of them involved incentives to promote the use of such features, including covered walkways, larger lift cars, etc. The submission also covered partly car park. And as members may remember, we have already improved the arrangements relating to exemptions for car park infrastructure. 100% of the car park 2 stories above the ground level have received 100% concessions from the total floor area calculations. As for streamlining of procedures, the Development Bureau and Buildings Department have been working hard on this. They have continuously updated some practice notes for professionals' reference. They have also expedited the processing of submission and approval of plans. As for the transitional arrangements, as we said on the last occasion, the amended rules will be applicable to buildings completed hereafter. For existing buildings, we do encourage them to retrofit such features. It is only mandatory if they are undertaking alteration and addition works. Otherwise, no change is needed. We do understand dissemination of information is very important. We want both the sector and the public understand what changes there are. We will make sure to disseminate information through appropriate channels to make sure there is good understanding of the public and the professionals. So that's it for our response to the submission. Let me now talk about our response to issues raised by members. We have 28 encouraged features, and these are set out in detail in Annex A of the paper provided by the administration. I will not spell out every one of them here, but basically, we would provide incentives when existing buildings retrofit such features, whether or not it is necessary for them to do so. We also want to, through the Development Bureau, as well as 2 different councils, such as the Beam Authority, if buildings make use of the encouraged features through the Green Building Council, the Beam Society, they can offer certification of a elderly-friendly building design, basically encouraging the adoption of relevant standards. As for the mandatory arrangements, some members talked about this at the last meeting. If people are just replacing floor surfaces or tiles, they do not necessarily need to comply with the new rules. We won't just knock on doors of private premises to see whether there is compliance of new requirements, but then we think as such arrangements are mandatory elsewhere, we should at least try to catch up. It is also for the benefit of citizen safety that they should comply with our requirements and put in place, for example, anti-slip or slip-resistant floor surfaces. We do not have specific requirements for single household buildings of building height of 30 meters or below because they are generally for single households. They will not share a public space with others. The public space is often not open to the public. We have also other provisions that are applicable for persons with disabilities not made applicable to such buildings, so we do not cover such buildings with our arrangements. We also will not regulate those with exemption certificates. We had extensive discussions in relation to basic housing units at the last meeting. Basically, basic housing units are separate units within a single domestic flat. But let me say, we have some requirements that are related to the general unit, say the door. If they are not replacing the door, then there is no change necessary. But for basic housing units, if they have already altered this before commencement of our legislation, then they do not have to make any changes. However, after commencement of relevant provisions for minor works, for example, if they have done some alteration works with their bathrooms, they would have to make sure to comply with the new requirements. But there is not much change involved. It would just be putting in place anti-slip or slip-resistant floor surfaces. And if you look at Annex B of the paper provided by the administration, the prices of slip-resistant tiles and general tiles are comparable. They may even be cheaper. And my team has actually brought some templates of tiles, so perhaps members can refer to that. You brought the actual tiles here, yes. Because we do understand domestic premises are involved and they want to show, well, perhaps my colleague can show the chairman and members the tiles. If you look at the tiles, they are generally available in the market at affordable prices. We don't believe there is a significant financial burden involved. As for transitional housing and light public housing, they are, as the name suggests, temporary in nature or transitional in nature. We only make our provisions applicable to long-term housing, so they are not covered. For non-compliance, are there any exemptions? We do provide exemptions for premises due to technical or other constraints cannot comply with such requirements. They can make an application to the buildings department for some alternative solutions. For example, a mirror-like finish in elevator is one of the requirements. If they have other alternative solutions for elderly persons and persons with disability to see whether the elevator door is open, it would be acceptable to us. As for what kind of building materials or designs are compliant with our requirements, for example, people are not required to press lift buttons now. There are sensors. So for automatic doors, we ask main entrances of new buildings to comply with fire safety requirements. So these should be generally acceptable and it should be easy for them to install such. If not, they can always apply for an exemption or alteration under Section 42 with the Buildings Department. As for other facilities, whether they have to put in place such features, it's actually very simple, the principle. As long as the categories are covered, for example, a private hospital or a public transport interchange, when they are completed after the provisions commence, they would have to follow that. If not, they don't have to follow the requirements. We actually also talked about the regulatory scope specifically in paragraph 17. So I will not talk about the details here. Let me talk about one more point. Public housing does not have to follow our requirements, but many of the requirements are already implemented in a way in public housing. Thank you. Thank you, Mrs. Elena Chen, the Deputy Secretary, and the reply provided by the Development Bureau and Buildings Department is very detailed, and you have brought some actual tiles here. I can see that you are prepared. I will assign at most half an hour to the discussion of further policy issues or comments on the responses. I will save 2 hours for the clause-by-clause examination. I can see that one member has pressed the request to speak button. So we have an additional member, Mr. Andrew Lam, and myself. I would like to speak as well. I will not draw the line here. I will assign 4-minute time limit. Mr. Yang Kip.
Thank you. I'd like to follow up on the public submissions and the administration response. There is an open space area and the canopy facilities. There is a 10% GFA exemption, which is an incentive for developers to build such facilities. Many existing buildings like to install such facilities, but very often these facilities are counted towards their GFA. After passage of the regulation for existing buildings, what happens when the developers want to build covered walkway? Will these facilities be exempted from GFA calculations or plot ratio? Second, I'd like to ask about the exemption mechanism. The administration said that if developers find it difficult to include some facilities, they can apply for exemption. I'd like to know more about the procedures for application. I worked with the buildings department when I was a district councillor. They are very strict. They ask very often developers to prove that they absolutely cannot build the facilities before they're exempted. For existing buildings that are completed, developers don't have engineers or architects in place to apply for exemption. Is the exemption mechanism simple in such a way that all buildings can apply for it easily? When substantial money is involved in building the facilities, and some buildings may have to convene owners' meeting before they can pass the procurement. I will answer the first question first, and then I will ask the BD to answer the question on the exemption mechanism. To put it simply, existing buildings can enjoy the exemption from GFA. The arrangement is the same for that with new buildings as long as they meet our requirements. For the second question, the buildings department, please. Thank you. For covered facilities, these are additions. The estates will not do it on their own. They have to either ask an architect to submit a building plan, and if the installation is minor in scale, they can do it through the minor works mechanism. They need to engage professionals to apply for the construction of such facilities. You ask about the procedures for applying exemption with the buildings department. It's not complex. As long as the buildings can prove that they have difficulties installing or building the relevant facilities, they can enjoy the exemption. Will you ask some professionals to prove that the buildings cannot include some facilities such as engineers, structural engineers, or architects? For fire services installations, very often we need to engage professionals to prove that they cannot, say for example, build a door of a certain width. How do we address such difficulties? For alterations of the doors, very often owners will not engage professionals. So I wonder if the owners can apply for exemption as long as they can submit some photos as proof. Thank you. Let me try to clarify. As I said, the mandatory requirements are for A&A that require approval of building plans or via minor works mechanism. If you want to do minor works, then you have to engage relevant contractors. For maintenance and repair, existing buildings don't have to follow the new mandatory requirement. If a building is engaged in want to engage minor works, if they want to alter the entrance, they may have to fulfill the mandatory requirements. Say, for example, in some cases, the structural wall or loading wall is installed in or constructed in such a way that you cannot widen the doors, you can just submit the relevant information to the buildings department, and then our colleagues will look at the building's plan and grant the approval. Next, Mr. Andrew Lam. Thank you. I'd like to ask about basic housing units. For redevelopment projects, they are about improvement. Not all old buildings need to be revamped because of the new regulation. My understanding is that we encourage existing buildings to make improvement. For regular renovations, for works that don't involve the approval of plans from the buildings department, then they don't have to replace their tiles to non-resistant or to slip-resistant ones, or they don't have to widen the doors. Well, I think that in this case, the regulation is reasonable. But if we have basic housing units covered by the regulation, then we have to be more careful. I think that we have to consider it because it's about the housing demand of our people. Against this background, I have 2 points to raise. Is the slip-resistant tiles more expensive than non-slip-resistant ones? The administration said that is not. I accept that. But as the regulation and the BHU ordinance are in operation in parallel, I think that we have to educate the public well about the regulations. Second, I think that the Housing Bureau need to look into the impact caused to the owners of basic housing units when this piece of regulation come into operation. I'm not sure if the showroom of the BHUs are built with slip-resistant floor. If it is not, then people may criticize you. Thank you for your reminder. We have been in close communication with the Housing Bureau about this regulation, and we also fully understand the importance of public education. When we publish the amendment regulation, we'll make sure that the public is well aware of our new requirements, and we will keep in close communication with the Housing Bureau on the basic housing unit. Next, Ms. Christine Fong. Thank you, Chairman. Regarding the amendment to Cap 123 of the Buildings Ordinance, there are 16 mandatory requirements and 28 incentives items. I support all of them. For bus terminus, MTR stations, these are not covered. For elderly, I think that it's important for us to designate, say, for example, a number of chairs, a number of lifts in MTR stations. On fire services ordinance, some elderly people may have hearing loss. I think that we need to install, say, lightings next to the alarm bell. I hope that there will be such facilities available in new buildings. As for the design of lifts, I do agree that we need to have sensors on both sides of the doors. In some large developments, they do have sensors at lobbies. I think that we need to have sensors so that people with disabilities or elderly using wheelchair can enter the lifts without pressing the open button. Some wheelchair users may leave the lift in reverse. I think that with the sensors, that will make it more convenient for them to go in and out of their homes. The administration said that some items cannot be covered. They may include it in the best practice. I think that we need to encourage that. I also agree that we need covered walkway. Some large developments accept population intake in phases. There is a large one in Chengquan-O that are in 13 different phases, and some of the buildings are not equipped with covered walkway. The administration said that they offer exemption. Some developers may only construct a covered walkway after the population intake is completed. I think also it's difficult for us to ask owners of residential units to submit building plans. Is there any incentives for developers if they help owners submit plans for alterations, for example? Deputy Secretary, thank you. I think that the first views are suggestions. We note them. We are reviewing our accessibility guidelines regularly. The LWDB gave us some suggestions. We may adopt them. Covered walkway are public facilities. During the consultation period, we have consulted friends from the construction sector. We do offer exemption from GFA for the construction of walkway. Developers are actually encouraged to include such a design. Not just elderly, I think that everyone prefer walking under a cover. So I think that's a popular design. As for the practice guide, as I mentioned earlier, we do have requirements on materials. We do have a few of such guide that have been updated for professionals in the sector. Thank you very much. Next, Ms. Kwok Foo-young, please. Thank you, Chairman. During the consultation period of the regulation, owners of basic housing unit have some questions. They'd like to seek clarification from the administration. BHU have a set of independent certification and examination mechanism. If the BHU is also subject to a minor works monitoring system, then owners of BHU are worried about the compliance cost that they have to shoulder. Will we allow, say, designated professionals of BHU submit certification on, say, our rating of certain tiles? I think that this applies to some other requirements as well. I hope that the administration can clarify.
秘書長。
All right, Mrs. Elena Chen, Deputy Secretary. That is not necessary. We do understand we have to make some clarifications of the process, as Mr. Andrew Lam said. I will perhaps ask Ms. Paylin to provide more details. Ms. Paylin, Deputy Director, thank you. For basic housing units, if they're applying for a certification, we need dedicated team members from the team handling basic housing units to approve and inspect such premises. And they would have to notify us under the buildings ordinance. We also do conduct random inspections. If the contractor is selected for inspection, they will submit records to us for us to find out more about their works. All right, any follow-up questions? If not, I would like to say this. Members can ask further questions on the supplementary papers and the administration's responses. I can see Mr. Yang Wing-kit would like to speak for the second round. I will draw the line here. After I have spoken, if there are no other members requesting to speak, Mr. Yang Wing-kit will be the last one to speak, and he will be speaking for the second round. Let me say this again. I will draw the line after I've spoken. After Mr. Yang Wing-kit has asked his questions or has spoken for the second round, we'll go into clause by clause examination. I would ask members if they would like to speak, seize this opportunity. All right. I would like to thank the administration for providing detailed responses to the issues raised at the last meeting. They even provided an example of slip-resistant tiles for our reference. I have some follow-up questions. I specifically asked about basic housing units at the last meeting. If we have subdivided units, later will be called basic housing units. If they are being constructed, they already comply with the provisions for basic housing units. They don't need to make any change. They only need to have a professional come inspect the units and certify that they are proper basic housing units. If they are not using slip-resistant tiles, what will happen, even though it is not a significant sum? Reverend Peter Kuhn also asked at the last meeting, some units already have slip-resistant tiles, but because the household does not have any elderly persons, they remove the tiles for some more beautiful tiles. You did provide response to this question to see if they have to restore the tiles, and you said if there is a complaint, you would issue an advice letter. In the end, will you initiate prosecution against such instances? My third question is, there should be a comprehensive review on whether the more encouraged measures would be made mandatory. I want to ask, in future, would you consider not having a comprehensive review? Instead, you just look at one or two specific measures to see if it should be made mandatory. so that you don't have to go through the whole process of consultation, review, and whatnot. Thank you. This is Selena Chen. Thank you. For basic housing units or single household buildings or general buildings, should I say, for domestic buildings, there is no distinction. The provisions will commence on 1st of August, and if the building is already completed by that time and there are no alteration or addition works to be undertaken, they do not need to implement the mandatory requirements. So basically, for basic housing units, even though they are making an application, they follow their specific provisions. They are completed before 1st of August. They do not need to comply with these new requirements. Regarding your third question, I would like to clarify with the chairman on this. I'm not sure if I understood you correctly. We have 28 encourage measures, or we provide some sort of incentives. Let me put it this way. Will you have 29th or the 30th measure in the near future? Let me put it this way. We do have a task force led by the Deputy Financial Secretary that would look at the practices in other places, for example, Singapore, for our reference. Things are indeed developing. We do not expect imminent changes, but if there are new technologies or developments or construction methods, we want to make sure to keep abreast with the times. We do understand what the chairman said about some households wanting to replace the slip-resistant tiles with their own tiles, with the tiles of their choosing. In fact, we have many construction materials, even fake marble tiles that look just like real marble tiles, and they are slip resistant. I think it's not just for the benefit of elderly persons, it's just for adults or children. They would benefit from slip resistant tiles. And especially when there is water, it is bound to be slippery. We do want slip resistant tiles, and in fact marble tiles don't work very well. Often water would seep into the cracks. We have different slip resistant tiles that have different patterns that can pretty much work for everyone. So we ask the owners to comply with the statutory requirements. We do not wish to cause a nuisance, but if we receive a complaint, we will follow up on that. And for the sake of safety, people should make use of slip-resistant tiles. I want to ask if you only issue advice letters instead of relying on other options for enforcement. Ms. Pei-Lin, we would want to start with the issuance of advice letters because if we are talking about self-owned units, if they just buy a property, if they do not have any elderly persons in the household, they may not want to change things up right away. But then we ask people to use slip-resistant tiles because they are really beneficial. Mr. Yang Wing-Kit. Thank you, Chair. I want to follow up on a specific setting. We do have some isolation facilities that may be used for other purposes in future, and perhaps you'll provide exemptions for those. If we have such special circumstances again in future, the large-scale facilities we build in a short time frame may not comply with your different requirements. Will you provide some sort of exemption still? Have you considered this in your provisions? I can see that you have covered different categories of buildings. But as I said earlier, in future, if we are to have community isolation facilities again, I am not sure if you have covered such emergency or special scenarios in your provisions. I will also ask specific questions during the clause-by-clause examination, Chair. Thank you. Thank you, Mrs. Alina Chen. Thank you. I'll give a brief response and then I'll ask my colleagues to supplement my reply. Should there be emergencies when we suddenly need, for example, community isolation facilities? In general, government premises are not governed by the Buildings Ordinance, but the Architectural Services Department, as the responsible department, would have reference to the Buildings Department. So, in essence, the member can rest assured this will not impede relevant progress, but I would ask the Buildings Department to provide specific details when there are some emergencies like this. Thank you. When there are major incidents, we will try to work with what we have. For example, community isolation facilities with the provisions, as these are mandatory requirements, the facilities should comply with the requirements. For example, for the selection of materials, they should have in mind patients may slip if non-slip resistant tiles are used. But then, say, for restrictions relating to width, in actual operation for community isolation facilities, they have modules they may not be able to comply with relevant requirements. We will practice a flexible approach in approval. That's what we can do. I have some follow-up questions. We are taking community isolation facilities in this same example. In emergencies, they may not consider putting in place slip-resistant tiles. Is it a must that they put in place slip-resistant tiles? Let me take community isolation facilities in Kai-Tak as an example, runway 1331. We may convert the facilities to other uses in future, but there are many restrictions that may restrict the conversion of the facilities. Can we make use of the exemption mechanism to deal with this? If you need to have alterations done, you have to follow all the specific requirements. You may not be able to convert runway 1331 to the uses the government has in mind. Would you have special considerations in such scenarios? I don't think your provisions cover this specific scenario. I would just like to seek clarification from you now, so that in future, should such circumstances arise, we will deal with this and we know what your intent is.
Thank you. The administration, please. To respond to Mr. Yang's question, why don't we include the arrangement in the regulation? Well, that's because in Section 42 of the Buildings Ordinance, we are already empowering the building authority the power. For private buildings, including isolation facility, if they want to alter or redevelop part of their buildings, if there are restrictions such as the position of the loading wall is placed in such a way that they cannot meet the requirements, they can apply for the exemption mechanism by giving us their buildings plan, and we will consider it. Understood. Take the runway 1331 as an example. I know that this regulation is about private buildings. A contractor is operating the runway 1331. So do they have to comply with the requirements? Any response? If after redevelopment the premises is still privately run, they can still submit their building plans to the buildings department. We do consider all their difficulties. But the buildings and the land themselves are government properties. Do we treat them as private developments? Can you repeat the question? Mr. Yang asked about the redevelopment of the isolation facility into a youth hostel. The operator is a private organization. Are they governed or regulated by the buildings ordinance? As the premises and the land are government owned, are they exempted? If the government has granted a short-term tenancy to the operator, that piece of land or the premises thereon are subject to the buildings ordinance. They do need to submit the building plans for development. For runways 1331, the relevant contractor did submit a buildings plan to the buildings department. Any other questions about policy matters of the regulation or the supplementary documents of the government? If not, let's proceed to clause-by-clause examination. And in accordance with the usual practice, we scrutinize the regulation based on the Chinese version. In the course of examination, we invite the legal advisor to remind members of the clauses that we should pay attention to, or legal or drafting issues, if any. The legal advisor did write to the administration regarding some clauses for clarification. When we come to the particular clause, we welcome the government making a response so that we can discuss it. Please refer to the marked up copy that have been sent to members. 767/2026/01. Let's start a clause-by-clause examination. Deputy Secretary, I will ask the Buildings Department to do it. Thank you. Please refer to the LN52 of 2026. The Secretary for Development under Section 38 of the Buildings Ordinance make the Building Planning Amendment Regulation 2026. The amendment regulation, in short, to amend the Building Planning Ordinance or regulations. The purpose of the amendment is to introduce elderly-friendly building design to make it more convenient for them to enter and leave the premises. There are 13 mandatory requirements for residential units, buildings, commercial buildings, or buildings with residential units or commercial units. There are 3 mandatory requirements that are applicable to residential units and buildings. I will walk members through the clauses one by one. First, commencement. This regulation comes into operation on the 1st of August 2026. Please continue. Regulation 2, Building Planning Regulations amended. They are set out in sections 3 to 6. Right. Amendment Regulation 3. Please refer to the marked up copy, page 0001 to 0004. We are introducing 4 new definitions under the interpretation part. They include residential unit, single household building, specified building, and specified public housing scheme. To amend the scope of regulation. So we should focus on page 4, correct? Yes. The first one is residential unit. We propose to introduce the definition because the mandatory requirement apply to residential unit. But in the existing buildings ordinance or the relevant regulation only cover domestic buildings but not residential unit. That's why we propose to add this new definition. To put simply, residential unit means a separate unit in a building that would have been a residential building had the unit been a whole building. We also propose to add 3 relevant definitions to make the scope of regulation more clear. Please proceed. The other one is a specified public housing scheme. It means a public housing scheme known as traditional housing or a light public housing. These housings are transitional in nature. That's why we exempt them from being regulated under the regulation. The other definition is specified building that cover single household building, B, a building the whole of which is under a specified housing scheme, C, a temporary building or a contractor's shed. To put simply, specified building do not cover the 3 types of structures. We want to reflect the applicability of the regulation by including this definition. Regarding the details, we will elaborate later on. The 4th definition is single household building. It means a building that is intended to be used for habitation by a single household. Although in the existing building planning regulation, we already have a similar term, but we think that single household building is more suitable. That's why we make this technical amendment. Regarding these 4 new definitions, I see that Mr. Andrew Lam and myself have pressed the button. Mr. Andrew Lam, please. Thank you. For all districts, commercial and residential buildings that are composite buildings, how do we apply the regulation to composite buildings? Regarding composite buildings, if we refer to section 73 bracket 1, it says that the regulation applies to a specified building that is a residential building, 2 that is a commercial building, or 3 that is neither a residential building nor a commercial building, but in which there is a residential unit or a commercial unit. So for composite buildings, the residential part will be regulated. For commercial units, they will fall within the scope of the regulation too. So this regulation applies to composite buildings. Chairman, this is what I am worried about. For composite buildings in old districts, the shops are not necessarily at the ground floor. We have some upper floor shops we have some divided units in composite buildings. In some leases of the buildings, we allow owners to convert commercial units into residential units. How do we apply this regulation to those buildings? Let me try to explain it. I think that Mr. Lam is talking about composite buildings with both commercial and residential units. For private buildings, they should have specified uses. For private buildings, they should either be industrial buildings or commercial buildings. If we're talking about composite buildings, then we have to now come back to our regulation. If the buildings are existing ones before the regulation come into operation, if the units are not subject to any alteration, they do not fall within the scope of minor works, then they don't have to comply with the new requirements. If additions and alterations are involved in such a way that minor work systems are invoked, then they need to submit their building plans and they need to comply with the requirements. Any follow-up questions? Let me talk about my understanding. So put it simply, for composite buildings with shops at second floors or third floors, they are equipped with separate toilets. After this regulation come into operation on the 1st of August, the shops are converted into basic housing unit, then they will need to they won't have to make any alterations to comply with the new requirement. Is that right? So if the layout of the shops fulfill the minimum requirements of BHU, they don't have to make any alteration. Is that right? Yes. Our regulation will come into operation on the 1st of August. If the units are completed before that date, they don't have to make any amendment. I have a question regarding this definition, single household building. What about civil service quarters? Are they exempted? Are civil servants' quarters regulated? For dormitory, there are hostels. I think we have to look at the design. For police quarters, they are government buildings. They are not regulated under the buildings ordinance. So I was talking about disciplined services quarters. So as long as we're talking about units provided by the government to their employees, they are not covered.
Please proceed. I ask members to refer to clause 4 and page 5 of the marked up copy. It is a consequential amendment in relation to Regulation 73 to be added. Regulation 73 is about the elderly-friendly building design requirements to be implemented. They are complementary to Regulation 72. If buildings are covered by the added Regulation 73, they need to also comply with the requirements under Regulation 72. So basically, with the amended Regulation 72. We will substitute the original paragraph A by a single household building of 13 meters or less in height above ground level, so that it would reflect more appropriately our coverage. Please go on with Regulation 73. We will ask members to refer to Clause 5 and page 6 of the marked up copy. We will add the specific regulation, that is Regulation 73. In particular, we have included building design requirements to facilitate elderly persons. We first talk about the coverage it would apply to residential buildings, commercial buildings, buildings that are neither residential or commercial buildings, but there is a residential unit or commercial unit, as well as a single household building of over 13 meters in height above ground level. Please proceed. Paragraph 2 is about how a building to which this regulation applies, or a residential unit in a building that falls within paragraph 1A, must be designed to the satisfaction of the building authority. And should there be overlapping in requirements with Regulation 73, the requirements in Regulation 73 are to be adopted. As I said earlier, Regulation 72 will complement Regulation 73 because in actual operation, the buildings covered by Regulation 73 will also be covered by Regulation 72. So such buildings will have to comply with both Regulations 72 and 73. Alright, I will now talk about paragraphs 3, 4, and 5. Basically, the design has to comply with the requirements set out in Part 2 and 3 of the fourth schedule. We will talk about the details in relation to the fourth schedule later. Basically, for paragraph 3, it would be applicable to residential buildings, commercial buildings, as well as buildings that have residential units or commercial units. They need to comply with the requirements set out in Part 2 of the fourth schedule. Paragraph 4 is applicable to a single household building of over 13 meters in height above ground level. As it is also a domestic building, it would be subject to both Parts 2 and 3 of the fourth schedule. As for paragraph 5, it is applicable to domestic or residential units, so it is subject to the regulation of Part 3 of the fourth schedule. As for paragraph 6, we have a definition of commercial units. We have the amended regulation being applicable to commercial units. We already talked about the coverage in general, and we will go into more detail in due course. Thank you. We have looked at Regulation 72 and 73, basically complementary requirements applicable to facilitate the access of persons with disabilities and elderly persons. We have already talked about the exemptions and scope. If we look at Regulation 72, it says specifically that it would not apply to single household buildings of a building height less than or more than 13 meters above ground level. What do you mean by this? Of course, I understand the important part is about single household buildings. then you have specified in Regulation 73, the coverage includes single household buildings 13 meters or above in height above ground level. Why is there a distinction in Regulation 72 and 73 in relation to single household buildings? Yes?
其實係啦，你講清楚就得㗎啦。
I think you just have to make clear of this. Alright? Well, Regulation 72 we were referring to what is not applicable in Regulation 72. But Regulation 73 is different. We are talking about where it is applicable. So basically, in 72, we're excluding the particular type of buildings. In 73, we are including a certain type of buildings. Right. So basically, single household buildings of over 30 meters in height above ground level, the requirements would be applicable. If it is lower than 30 meters in height, it would not be applicable. Yes, I can see Ms. Christine Fong has pressed the request to speak button. Basically, houses that are standalone houses or townhouses less than 30 meters in height, the requirements will not be applicable. I think that is not ideal. I think elderly persons, regardless of where they live, they want accessibility. And we do have houses installing outside or external lifts. Even if you're not including them in the provisions, I think you should include such requirements in the guidelines. I also want to ask for shops, department stores, and places of public entertainment in Regulation 73. With these premises, what specific changes or major changes there are? Can the administration elaborate? I think if we refer to the PowerPoint presentation, for commercial buildings, we have, say, for department stores, places of public entertainment, they will be covered. In the regulation, we did not spell this out because for commercial buildings, there is a definition in the buildings ordinance. For architects submitting building plans, they already know which buildings are covered. But perhaps in the practice notes, we can provide some clear examples or we can tabulate such information. Alright. Mr. Augustine Wong. Thank you, Chair. I just have some clarifying questions. Say in Clause 3, for specified building, it means any building that is not any of the following. And one of the categories here is a single household building. But in Regulation 73, basically you're covering single household buildings of over 13 meters in height. So these are included as specified buildings in a way, no? Or is it the case that everything is covered except for single household buildings that have a building height of lower than 13 meters? So I want to ask, since you have already provided definition for specified buildings, why did you have to provide another definition in Regulation 73? Mrs. Alina Chen. I will try to provide an explanation. Basically, the scope would cover private buildings with long-term domestic uses or long-term commercial uses or commercial residential use. We also have some specific requirements applicable, which is why we believe there should be a proper definition. We do take the threshold of 13 meters. Single household buildings above 13 meters in height will be covered, and those lower will not be covered. I have some follow-up questions. We are talking about here a single household building of over 13 meters in height above ground level. I think there is a distinction between single owner building and single household building. The owner may rent the building to more than one household. So if we have a single household building, but it is housing 2 to 3 households and it is lower than 30 meters in height, which requirements will be applicable? If we have more than one household in the building that is less than 13 meters in height above ground level, it is not to be understood as a single household building. We're talking about which types of buildings are regulated under this regulation. If you have more than one household living in the building, this definition should not apply in the first place. Let me provide some supplementary information. We are not subjecting single household buildings with a building height lower than 13 meters to our regulation because they will not have public access. We will not have general citizens, including elderly persons, being in the area. We are excluding it because of this unique condition. But if there are many people living there and there is access by different types of people, it would not be our legislative intent to exclude such types of buildings. I think part of their reply partly answers my questions. Say in future, if they have no alteration works done, even if this condition is met, they will not be subject to the requirements. But if they sell such property, then they will be subject to regulation, right? Right. All right, any other questions from members? If not, we'll proceed. All right. I'll ask members to refer to clause 6, that is page 8 of the mocked-up copy. We are adding after the third schedule the fourth schedule, specifying mandatory building design requirements to facilitate elderly persons. Building design has to comply with requirements in the fourth schedule to the satisfaction of the building authority, and the specific requirements are spelled out in this schedule. Basically, there are 3 parts. We have the first part being preliminary and the definitions. Part 2 are the design requirements relating to regulated route. And we have for part 3 the design standards for regulated domestic units. In part 1, we have provided the specific definitions that would include specified residents, wheelchair users, route residents, required staircase, regulated route, public exempted route, door, and accessible lift. Take regulated route as an example. The 13 requirements in Part 2 of the 4th schedule will be applicable to regulated routes, which is why we need a definition of regulated route so that the public knows what will be covered. Basically, for the 30 requirements, they will be applicable to buildings that fall within Regulation 73(1)(a), that is residential buildings, commercial buildings, or buildings with residential or commercial units, and the route for access to such buildings. That would include A1, a route provided for the building in compliance with Section 2(1) of the schedule, as well as a route in the building that provides access to a residential unit and specified residents that may or are permitted to use, as well as other leisurely premises.
高於13米嘅
For single household buildings taller than 13 meters, the regulated route will mean access connecting the streets to the relevant premises. Mr. Andrew Lam. Interpretation. Under 4th schedule, I believe that apply to 4th schedule only. I'd like to know more about the definition of wheelchair users. I don't think that wheelchair users are mentioned anywhere in the 4th schedule. Have I missed anything? If we're not mentioning wheelchair users in the 4th schedule, why do we need a definition for it? The Chinese translation of wheelchair users is 坐輪椅人士. I understand that why it is translated in such a way, but we have to be mindful of the fact that there are many new devices coming up in the market. According to your definition, wheelchair users means people who rely on wheelchairs to move around. Is wheelchair the only tool that help people move around? Not necessarily. The applicability of the definition is limited. I'm not asking you to amend it now, but I think that you need to note it. Now coming back to the interpretation, where in 4th schedule is wheelchair user mentioned? If you refer to page 14 of the markup copy bracket 4, or rather bracket 3, it's under clause 9 bracket 3. Wheelchair users is mentioned under accessible lift. It has to be finished in a manner that will assist wheelchair users. Got it. Thank you. Please proceed. Now we've come to part 2 of the 4th schedule, clause 2 and clause 3. My apologies. We're just at a regulated route. What about exempted route? Specified resident? Are we done with that part? In many of the definitions in Part 1, we quoted many from the 3rd schedule. Mr. Andrew Lam. In Part 2, Clause 2, Bracket 2, for special landscape conditions, regulated route will not apply. When you're drafting the bill, what environment or special landscape conditions do you have in mind such that the relevant development will be regulated? We're at part 2, clause 2. Can I walk members through part 2? I thought we were done with part 2. My apologies. Part 2, please. Now we come to part 2 of the 4th schedule, clause 2 and clause 3. Please refer to page 0010 of the marked up copy. Clause 2, provision of routes from lot boundary to building entrances. And the routes will form part of the regulated route under the 4th schedule. And it has to comply with clause 3. I can explain to members the reasoning behind clause 2. Clause 2 says that a route may be provided for a building from a prominent point that is on the boundary of the lot on which the building is erected and that provide access to a public street or pedestrian way. And it does not apply if it's impracticable to comply with that subsection because of difficult terrain or unusual characteristics of the site. The appointed authorized persons can set out clearly the actual limitations of the site in the plan. In accordance with Section 42 of the Buildings Ordinance, they can apply for exemption from the Buildings Department. The department will consider each and every case based on their special circumstances. Please continue. Clause 3, general requirements for regulated routes. It says that the floor space of regulated route must be firm and slip resistant. The regulated route in an indoor area of the building must have a clear width of no less than 1,200 mm. And there's also illumination requirement. It will promote accessibility of the regulated routes and make it safer for elderly to move around in these routes and encourage them to go out of their home. And I'd like to now talk about clauses 3 and 4. Subclause 3 says that there should not be any fixtures, fittings, or appliances projecting beyond 90 mm from the surface of any wall adjacent to the route in an indoor area of a building below 2,000 mm. But in 3(5)(a) says that subsection 4 does not apply if the appliances, a fixture, or fittings are unavoidable on reasonable ground. Let me give members some example. In existing fire escapes means or access, there may be power control panels. If we are to relocate them, it may not be feasible. Under such circumstances, authorized persons can apply for special considerations or exemptions from the Buildings Department. In 3(5)(b), it says that Section 4 does not apply if the appliances, fixtures, or fittings extend downwards to the finished floor level or the regulated route or are guided by textile flooring materials. This will allow the pedestrians to walk more freely. And if the fixtures are guided by tactile flooring materials, then the pedestrians can also avoid the obstacles. Please proceed. If that's the case, now we come to Clause 4 of Part 2 of the 4th schedule. Please refer to page 0012 of the marked up copy. Dimension of main circulation staircases. It sets out the width of the tread and height of the riser. The tread of a step should not be less than 300 mm in width. The riser should not be more than 150 mm in height. Under the mandatory requirement, the tread of the main circulation staircases should be wide, and the riser of a step in the staircase should be not more than 150 mm in height to promote accessibility and safety of elderly. In Clause 5, dual level handrails of main circulation staircases. These dual level handrails need to meet the relevant installation requirements. As I said earlier, in Section 73, we do have a set of mandatory requirements for elderly-friendly building design, and they need to be complied with in tandem with Section 72 about the relevant design requirements for persons with disabilities. So the fourth schedule of Section 73 should be complied with in tandem with the other regulations for persons with disability design requirement. The handrail must meet the certain loading requirement. There are also height requirements for handrails to promote commute and accessibility of elderly. The administration have already covered clauses 2 to 5 on handrails, illumination, circulation staircase in Part 2. Any questions? The administration has already explained about the exemption. Now I have some question. It says that if it's impracticable to comply with that subsection because of difficult terrain or unusual characteristics of the site, for new buildings or existing buildings, will there be any distinction of? Now, in terms of the exemption mechanism, is there any difference for old buildings and existing buildings as well as new buildings? To put it simply, will the administration be more lenient with existing buildings and stricter with old or existing buildings? My second question, Clause 2, Bracket 2. Does it apply to just subsection 1 or the entire Part 2? For new buildings and existing buildings, as we all know, owners or developers may have difficulties in meeting the requirement. It's not to say that we're going to be more lenient with existing buildings. They may have true justifications to support the inability to comply with the requirement. Because in some developments may be situated on a very steep terrain, they may not be able to meet our entrance requirements, for example. Second, does 2 Bracket 2 only apply to subsection 1 or the entire part? While regulated route cover the access from the street to the entrance of the buildings and some common parts of the building, we have to look at the design of the buildings. Is it the case that the developers cannot meet the width requirement of the regulated route? We have to look at all applications on a case-by-case basis. Well, I'd like to ask about Clause 2, Bracket 2. It says that the mechanism does not apply if it's impracticable to comply with the subsection, will developers be exempted if, say, they have difficulty complying with regulations apart from the regulated route? Thank you.
啱嘅，
I think the understanding is correct. If we're talking about the inside of buildings, there should not be a setting of uneven terrain or special circumstances. But we do understand there may be steps within building if there are alteration or addition works, and under some special circumstances they cannot comply with our requirements, we can act in accordance with Section 42. But this is applicable specifically to Part 2. Right. So basically, this exemption only applies specifically here. Well, it is in other scenarios it is not applicable because there should not be uneven terrain. We do have Section 42 of the Buildings Ordinance to deal with different exceptions. Thank you. Mr. Aaron Bach. Thank you, Chair. I think we're looking at page 12 of the marked up copy, right? And we have here main circulation staircases and handrails of the staircases. I believe main circulation staircases refer to the main entrances, and they're not made applicable to fire escapes. Where does this basis come from? I also want to ask if there is a definition for handrails. I don't see a definition from earlier. I want to ask if handrails are applicable in general. The handrails have to meet certain specifications. There is a loading requirement. If we have specific requirements to handrails, why not have a definition of handrails? Thank you. Well, actually, in Regulation 72, there is a set of description in that, and which is why we do not think there is a need for a specific definition here in Regulation 73. I will ask the Buildings Department officer to answer the other questions of the member. Well, actually, in preliminary, we already talked about how regulated routes would not cover specific staircases. Perhaps we should refer to page 10 of the marked up copy. It talks about, well, are you talking about page 10 of the marked up copy for exempted route? Well, page 10 of the Chinese version, basically exempted route, it should not cover, it should cover required staircase that means a fire escape, so it is exempted. And in page 9 of the marked up copy in Chinese, we talked about required staircase has a meaning given by the third schedule, and it is a staircase for emergency access or rescue. Basically, in law, it already took into account what Mr. Aaron Bach said. With the commencement of the relevant provisions, it will not affect fire escapes. Correct? Correct? Is that all right with you, Mr. Aaron Bach? I will look at other regulations for the definition of handrails. All right. We will go back to point 6 of part 2 on page 12 of the marked up copy. I will ask members to refer to both points 6 and 7 of part 2, and we have for specific requirements for width of doors and door thresholds. We ask specifically for door thresholds, they should not be more than 15 millimeters in height, and they should be beveled and have a round edge to facilitate elderly access. Let's move on to point 8. For lifts that are regulated routes of buildings, they must have an illumination level of not less than 120 lux. This is comparable to the illumination for regulated routes indoors. Regarding point 9, it is applicable to accessible lifts that are regulated routes of buildings. The specific requirements are for internal car dimensions. In width, it will increase from 1,100 millimeters to 1,200 millimeters. For depth, it will increase from 1,200 to 1,400 millimeters. There should also be mirror-like finishes so that for wheelchair using elderly persons, they can look at the surface, which has a mirror-like finish, to see if the lift door has opened so they can move out of the lift. Let's talk about point 10. That is page 14 of marked up copy in Chinese. It talks about for residential buildings or buildings that are not residential buildings but have residential units. They should have automatic doors so that elderly persons don't have to push or pull the heavy doors. It can also provide access to elderly persons using wheelchairs or mobility aids. All right? Members, for lifts or automatic doors, are there any questions? I can see 2 members have pressed the request to speak button, Mr. Lam Ran Kwong. Thank you, Chair. I first want to ask some questions on lifts. We said there should be a mirror-like finish. Will you have specific requirements for the finish, for the location, as well as the dimensions? I have a photo here. There is a mirror-like finish for the surface facing the door, but not on the 2 sides. Would that already comply with the requirement? Or do you have more specific conditions? We also have in paragraph 3b that is applicable to an entrance of the lift that faces another entrance of the lift. Are you referring to, say, other kinds of lifts that may have more than 1 set of doors? Ms. Paylin, the member's understanding is correct. For the surface facing the entrance of the lift or entrances of the lift, there should be a mirror-like finish. As for whether there are specific requirements on dimensions, how far it has to be from the floor level, the size, there are already suggested dimensions in the design manual. The mirror-like finish should not be too low because people can damage the finish, and you also have to consider how wheelchair using persons eye level. when they set the mirror-like finish. Will this be in the mandatory requirements? It is already in the design manual at the moment. When the requirements becomes mandatory in future, they will have to comply with the dimensions condition. Thank you. Mr. Augustine Wong. I also want to ask some questions on the mirror-like finish. There are different designs. Some make use of a television. They have different ways to make a mirror-like finish. Can you be specific? Because this is not stated in law. Is a similar effect acceptable? Ms. Pei-Ling, We do not ask for specifically a mirror to be installed. We just have regard to the principles, and if there is a new kind of material or new equipment that can achieve a similar effect, and if they can provide information to us that it can achieve a similar effect, one can make an application for the alternative solution, and we will consider it and may accept the solution in a flexible manner. I also have some questions myself. For existing buildings replacing lifts, for illumination and mirror-like finish, I don't think there is an issue, but the lift is already of a certain size. If they cannot accommodate the increased dimensions of the internal cars, how will you deal with such situation? And I also want to ask if the EMSE is notified of such requirements and they can accommodate such requirements, and have they consulted stakeholders? Is it easy to comply with such requirements? For automatic doors, do you have specific requirements? Can they be sliding doors, whichever direction it slides, or there are no doors at all, or the direction of the opening of the automatic doors? Do you have specific requirements? Ms. Pei-Ling, actually, we do not have specific requirements for the direction of opening of the automatic doors, but we do have requirements for the width of the doors. Say if they are sliding doors, with a sliding mechanism, they cannot achieve a width of 850 millimeters. That would not suffice. Otherwise, it should be fine. As for lift moderations, we do not ask people to comply with the new requirements if they're replacing tiles, and a similar principle is practiced for lifts. And we also practice the same approach for mirror-like finish. As long as they're able to do it, they should do it. When we consulted stakeholders, we let stakeholders know with the new requirements they are to facilitate elderly access, and these are not exactly hard to implement. Basically, in policy, if you are just replacing the specific facilities, there are not mandatory in terms of points 8 and 9. We have all along taken this direction. When you're just doing maintenance, we do not ask for you to provide upgrades. But if you can do it, I believe residents want this as well.
唔能夠強制。
I think that for point 9, we cannot mandate that, but for point 8, I think that we should encourage developers to improve the illumination level of their lifts. Please continue to talk to the trade. I believe that it's easier for you to reach out to the lift sector. Ms. Christine Fong. Thank you, Chairman. I'd like to ask about automatic main entrance doors. Fire escape may be involved. Some shopping malls are connected to bus stops, and that's why some of the doors are opened towards the shopping malls. It's difficult for wheelchair users to enter shopping malls in such a case because they have to move their wheelchair in such a way, in a specific way, for the doors to be closed. For new developers, when they build their shopping malls, I think that they should build sliding doors instead. This will make it convenient for wheelchair users. I wonder if the administration will encourage developers to make upgrades using the practice guide or practice note for commercial space. Deputy Secretary, please. Thank you. We may include practice guide in the notes. Mr. Yu Pak-leun, Deputy Chairman. Thank you, Chairman. I'd like to follow up on the mirror-like finish requirement for lifts. We all know that sometimes we don't have mirrors inside lifts. We're not asking the developers to install a mirror inside the lift. As long as, say, for example, a piece of aluminum have mirror-like finish, we will allow it. Is that right? For some screens, if they're not on, if they're not displaying advertisements, they are mirror-like. Can they meet the legal requirement in such a case? The administration, please. Yes. We talked about mirror-like aluminum or stainless steel. We allow for that. Some mobile phone screens are also mirror-like. Ms. Kwok Foo-young. Thank you, Chairman. I'd like to ask about automatic doors as well. Automatic doors are machines and sometimes they are damaged. I do agree that we need to install automatic doors to facilitate the mobility of wheelchair users. But there are some operational details that we have to be mindful of. We have to look at the directions in which the doors are opened. These are some of the design problems that we may have to address. My second point, when the automatic doors are out of order, are the operators required to open the doors permanently, or are we asking the wheelchair users to use other doors? And is there a mechanism in automatic doors to allow for manual opening? Automatic doors are like lifts and escalators. They are supervised by the EMSD. Now we are mandating the installation of automatic doors at main entrance. I think that the administration needs to give developers or contractors or property manager more guidance. We're going to mandate the installation of automatic doors, but it seems that we don't have any guidelines for developers. I'd like to have more information on the actual operation of the automatic doors. Thank you. Regarding Ms. Kwok's questions, automatic doors are nothing new. For commercial buildings, automatic doors are commonplace. When we have automatic doors near the fire escape, when there's electricity or power outage in the buildings, the operators or contractors need to open the doors at all times. We do have such a requirement for restaurants. Maybe we will formulate practice note to clarify it. We'll consider it. But in fact, in many commercial buildings and many restaurants, when there's power failure, they open their automatic doors at all times. Any follow-up questions? Thank you. I think that the administration was talking about shopping malls. But when it comes to single block buildings or new buildings, I think that we need more guidelines or guidance for those developers. For new buildings, when the automatic doors are out of order, we may be worried about the safety of the people, of the pedestrians, and building safety. If we don't have a clear set of guidelines, then the property management office may just close the doors and ask the residents to use another entrance. This will make things more difficult and more inconvenient for elderly residents. So I hope that the administration will set out a clearer guidelines as to what the property management office or developers should do when the automatic doors are out of order. We may launch a promotional campaign together with the Property Management Association. Thank you. I know that the legal advisor has something to add. Thank you, Chairman. Regarding the handrail issue of Mr. Bok's concern, I have some additional information. In Cap 123F, the third schedule is not included in the interpretation, but it's in Division 8 in Schedule 3. There are requirements on the dimensions, the shape of the handrails. It's defined there. Thank you. So you will put the description of the handrail in Part 3, is that right? Regulations 72 and 73 should be read together. For Regulation 72, they're about accessible design for persons with disabilities. In the third schedule of persons with disability in Regulation 72, we already have set out the dimensions and shape of handrails. For elderly design, we need a dual handrails. They are not in conflict with Regulation 72. We're not going to repeat what's set out in Regulation 72 in Regulation 73 about the design of the handrails. Well, we lean on handrails to walk sometimes. So I think that we need to focus on the loading. We may have to specify the length of the screws. Is that laid out in Regulation 72 already? We do not specify the length of the screw, but we specify the loading of the handrails. When the architects and engineers work on it, they have to take into account that factor. Thank you. Regarding Part 2 of Regulation 73, I think that we have completed our clause-by-clause examination. Any further questions? If not, let's come to Part 3. Thank you, Chairman. Please refer to Part 3 of the fourth schedule, clauses 11 to 13. That's page 0015 of the marked up copy. As I said before, there are three mandatory requirements. First, width of main entrance doors, it should not be less than 850 mm. The threshold of main entrance door should not be more than 15 mm in height and should have a beveled and round edge on each side. Clause 13, the bathroom, kitchen, and toilet floor surface should be slip resistant. The slip resistance standards will be set out in the practice note clearly. These are the details of the clauses of the amendment regulation. Thank you. Regarding the three mandatory requirements in Part 3, any questions? Regarding the slip resistance standard, you said that you will include that in the practice note. Can you clarify it now? Deputy Director? Thank you. We have conducted a consultancy study. We have made reference to standards all over the world. We're going to adopt a R rating standard. This is an internationally recognized standard. For indoor units, we use an R10 standard. For outdoor units, we use R11 standards. In the practice note, we will set out clearly the AS standards that R rating follow. Most materials on the world are manufactured based on this set of standard. Do we have any other set of standards in the world other than this R standard? Yes, there is. We have made reference to the relevant standards in Japan, Singapore, the mainland, Australia, UK, US. I believe that this R standard is the most commonly adopted standard. Mr. Augustine Wong. Thank you. I have a simple question regarding the threshold. We mandate the installation of threshold at main entrance doors, but it is said that the threshold should not be more than 15 mm in height. When we alter the bathrooms, is there a threshold requirement for bathrooms? We have set the maximum height. Well, we have set out the maximum height of the threshold. It's okay if a bathroom does not have a threshold. Mr. Yu Pak Lang. Thank you, Chairman. On slip resistance standard, thank you for bringing the samples tiles to here today. I only learned about the difference between R10 and R11. They're just one class apart, but it seems that the slip resistance level is very much different. I wonder if the administration will use R11 for outdoor areas in government premises. Apart from indoor units, I think that we need to make our outdoor area more elderly friendly as well. This is a good way for us to safeguard people's safety. I have another question. On automatic door, how automatic should the doors be? When the sensors at the automatic door sense us walking towards the doors, they may open automatically, but sometimes we need to tap the cards on a panel before the doors are opened, and sometimes the automatic doors will not open unless we have invoked the facial recognition function. Is there a definition for automatic doors?
講得好。
That's a very good question. In terms of policy, for public housing or general government premises, they are not subject to the regulation of buildings ordinance, but in operation, Architectural Services Department and the Housing Authority have in mind their relevant practices, and they are already using slip-resistant tiles. I believe it is not far from what the member expects. As for automatic doors, as the Deputy Director of Buildings, to answer the relevant question. As for standards, I believe Architectural Services Department already promulgates the specific slip resistance standards in the contracts. As for automatic doors, the aim is to not have elderly persons having to push open doors, so automatic doors should be installed. Whether a mobile sensor is used or one tapping a card to open the door, there are no specific requirements as long as it doesn't require people to open doors by force. Alright, so as long as they tap a card and the door opens itself, it will also fulfill the requirement for automatic doors. Right. Alright, let me say this. I would like to thank Mr. Ko for leading the clause-by-clause examination. We have basically concluded the clause-by-clause examination. Are there any other members asking for further clarifications from the administration in terms of the provisions or the policy? Mr. Aaron Bach. I do understand that for the newly completed buildings, the requirements would automatically apply. For existing buildings, if they are to undertake alteration and addition works, the portion where the alteration or addition works will be subject to the new requirements. I want to ask in law or in the proposed provisions, where is this spelled out? I'm just afraid that there may be potential disputes. So can you specify which part said it only applies to the portion where alteration and addition works will have taken place? I want to make clear something. In fact, the explanation we offered on the last occasion is very clear. If people are undertaking works for the toilets, we think it is unfair to subject them to all the new mandatory requirements. So the principle is that if they are undertaking alteration works in the toilet, the requirements specific to the toilets will apply. I'll perhaps let the Deputy Director supplement my reply. We would refer to Section 39(2) of the Buildings Ordinance. For example, when there are alteration or addition works to be carried out, the specific scope, the portion, will be subject to new requirements. If I can just look at the specific provision now, excuse me. Is it Section 39?
好，
Right. Deputy Director. As I said earlier, we will determine the scope of application of new regulations, for example, when there are alteration and addition works, it should apply. But how we're going to define the portion where the new requirements should apply, when the sector should know when they submit plans, we will see specifically where the works are carried out. They will not submit a plan that shows, for example, the whole floor. So basically, what is stated in the plan is the portion for which the new requirements will be applicable. I think we can communicate with them after the meeting, because there was an instance where we started very small and then eventually the whole unit had works carried out. I think Mr. Ehrenbach's question is quite valid. Up to where the regulation will apply. Perhaps you can provide a written response to us after the meeting to clarify the situation so that the sector can rest assured. Mr. Yu Potland, Deputy Chairman. During the clause-by-clause examination, members asked many clarifying questions, and I think it clarified many of the relatively fake expressions. I also have a clarifying question. Before we have requirements applicable to single families, now it's single household. Is there a definition for households? For single household buildings, if you have different families staying in the same building, say extended families staying in the same building, would that be seen as a single household? Can you give a more specific definition? Mrs. Alina Chen. Thank you. Let me try to give you an explanation. We specified single household exactly because we communicated with the Department of Justice, and we found in some provisions there is a definition for family. It is often referring to family with people who are married or are related by blood, but that does not cover, say, couples who are living together who are not married. Right, so it is why we want to differentiate from the situation where people have to be related by blood. So we use the concept of single household to match our legislative intent. I hope this explanation is enough for Mr. Yu to say why we didn't use single family instead of single household. I think it can also be quite dynamic. Sometimes we will have a building housing more than one household temporarily. We do have a specific restriction where the houses have to be 13 meters in height. Over that, in terms of ground level, I don't believe there are a number of houses that are 13 meters or below. I think we should really clarify the different circumstances. I want to ask, if we have two families, even when we're not renting out certain premises, that would not be seen as a single household, right? We do try to talk about in the definition of single household buildings, we have in mind the building height restriction, because if the building height is certain meters or below, it general should not accommodate more than one household. If there is no rental relationship, we do not want to cause a nuisance and make them comply with the requirements. But when they construct the building, having in mind that it is going to house more than one household, it should not fall within the definition of a single household building. I think we should take this perspective. Thank you. If members have no other questions, I will ask the legal advisor to confirm if there are any other issues with the Chinese or English versions of the amendment regulation. On top of the questions we raised in our letter on 3rd of June, we have not identified other legal or drafting issues. All right, so you're referring to the Chinese version, right? Any other issues with the English version? We have not identified any legal or drafting issues with the English version either. Thank you. We have completed clause by clause examination. Before this meeting, the Secretariat has not received any proposed amendments from members or the administration. If members would like to propose amendments for the consideration of the subcommittee, I ask members to submit proposals before noon on Wednesday, 24th of June, to the Secretariat. The Secretariat will ask the administration to provide a response. If the administration would like to propose amendments, please submit them to the subcommittee for consideration as soon as possible. As the schedule is quite tight, I want to ask if members would agree that we can simply, by circulation, consider the following documents, if any: the written response provided by the administration on issues raised at this meeting, as well as the proposed amendments of members and the administration and relevant responses. Do members agree that we can simply circulate such documents for consideration? If there are indeed such documents, if members wish to convene a meeting to discuss the responses, please inform the Secretariat of such. As for the legislative timetable, would members please note this? As discussed at the meeting on 9th of June, I moved a resolution on 17th of June at the council meeting to extend the scrutiny period to the council meeting on 15th of July. So the deadline now is 15th of July. The date that will make a report to the House Committee is 3rd of July. As for the deadline for giving notice on amending the subsidiary legislation is 5 p.m. on 8th of July. So that's it for the legislative timetable. Any other questions on the proposed arrangements for the subcommittee that I mentioned earlier? If not, we have completed clause by clause examination. We have no other business. Meeting adjourned. Thank you.